Welcome back, viewers, to the Personal Injury Show. We've been talking about nervous shock claims. Tony, we were talking about the Annette's case.
Annette's is the current law on nervous shock in Australia.
That's correct.
Tell us about Tame. There was a case of Tame and Tame.
Well, Thames was considered at the same time as Annette's by the High Court. Thames involved a lady who was involved in a bingle, a car accident.
Little old lady, yeah.
Yeah, little old lady, and a police attended, and the police prepared a police report. The other driver involved in the accident had some alcohol, so he's
Son, he was
breathalyzed
3 times over the limit, though.
pretty high, and the police report was prepared on that basis. But unfortunately, there appeared to be an error when the police did write down who had blood
Who was
alcohol involved.
alcoholised.
That's right. So in the police report, they actually put down that both drivers, including Miss Thames, she had a blood alcohol reading of the same level as the other driver. And that was soon found out in her recovery claim for her damages to her vehicle.
So she
about
finds
this
out.
mistake.
So she
Yeah,
finds
her
out.
insurer
about it.
finds out, John.
All right.
Or, sorry, her insurer denies the claim because of the alcohol.
And she finds out about this, and what happens then?
She
Well,
develops a...
The police did rectify the problems pretty much straight away as soon as it was found out. But she developed this psychiatric condition or illness as a result of this mishap or mistake.
How?
She just became, unfortunately, obsessed with the whole... She thought that because this was on the public record and it was available, public record is available for, the police report's available for a fee, that people would find out or believe that she was at fault.
So we've got a situation where we've got a lady that's developed a obsession about what's occurred.
She had an obsessive
So
type personality.
It's her personality that we're talking about here. Okay,
It appears
yeah.
so.
All
She
right.
was, the psychiatric illness from a condition from it included like insomnia, anxiety.
So-
it was pretty
so
extreme.
She was
On what
obsessed.
basis-
She was obsessed that because of the incorrect recording of the alcohol limit, that's why the insurer denied her claim for physiotherapy treatment and things like
But then
that.
why has she made a claim for this obsession then?
Well, she said it came
How's
on
that
because
possible?
She said by reason of the mistake made by a police officer, it's caused her this psychiatric illness, John.
what it's done, John, is it's brought into the
Okay.
test a level of reasonableness. You can't take it too subjectively. It's more of a reasonable man test, a reasonable lady, because in this case here, her idiosyncratic behaviour had led to the condition that she had.
Well, the law's not designed for this, is it?
No, and look, the law, or the High Court in this case, did say that her response to it was far-fetched or not what you expect.
Of a person of normal fortitude.
That's correct. And that's a test that they put in that.
Mind you, they even gave her a formal assurance it would be fixed, and they also apologised to her.
So we've got the reasonable, in this case, woman test, haven't we?
Hey, John, you got your desired result. She failed. She lost.
Well, Tony, we don't want spurious claims. We don't want claims that, about people making
Could you-
obsessions, talking.
Could you
We just
imagine?
don't want claims like
You'd
this.
almost be able to sue every time someone says something the wrong thing about you.
Exactly, and we don't want the legal system clogged up with this type of stuff.
And that's what the law's concerned about, Don. They're worried
that's
about
right.
opening the door too much, so then you've got claims right across the board.
But
So although the High Court did change the test from having that sudden shock or immediate aftermath, witnessing the immediate aftermath of an
Yes.
accident, it did put the test of normal fortitude. So if it's an extreme response to what one would not expect, then a claim will fail.
But
It's not
Don,
reasonable
normal
to sue.
fortitude isn't a test in itself. It's part of the foreseeability
That's right.
aspect of the
That's right.
the test, causation.
That's right. So it's a test of whether or not the psychiatric illness is reasonably foreseeable.
There was another case decided in Victoria of Solity. Just briefly, Don, because time flies when
Just
we're doing.
on a matter of solitude, it was a Victorian case considered by the Victorian Civil Administrative Tribunal. It dealt with Miss Solitude, whose son was hit by a train and subsequently, unfortunately, died as a result of that accident. And she did not witness the accident. She did not see the body after the accident. She did not attend the morgue. There was a closed coffin casket at the funeral. But what happened in Solitude...
And she was advised not to see the body because it was a mess. Yeah.
But she did suffer from nightmares after the accident, after distressing nightmares
So
about the son.
she suffered a nervous shock.
She suffered a nervous
psychological
shock.
condition
That's right.
arising out of what's occurred to her, as in the grief that she's suffering.
No, not the grief. You can't get compensation for grief, John. It would have to be a post-traumatic stress condition
All right.
and
It went
a
beyond
properly
grief.
diagnosed psychiatric condition.
Nervous shock.
It went beyond grief and sorrow. But in Soliti's case, she lodged a claim for compensation with the Transport Accident Commission, and the claim was rejected at first instance, and it went to appeal at VCAT. In that case, it dealt with the definition of injury under the Transport Accident Act. And the definition of injury includes physical injury or mental injury, and that can include someone who's witnessed the aftermath of an accident or witnessed the accident. So the court considered the wording of that definition of injury.
And the court found for the Mr. Solity on the basis of Annette's decision, correct?
That's right. By reason of having the word includes in the definition of injury, it was an exclusive definition, so it was parliamentary debate about it all. It was pretty much that it can include someone, as in Annette's case, who is closely and has these love and affections with
Don, I don't want to be
person.
too technical about the law. Let's bring it back to the individual circumstance and examples we can give the public, John. In the accident compensation field, when could you sue?
Well, for stress and anxiety arising out of a work injury,
An industrial death?
death, that type of instance, it needs to be direct. Particularly when we're talking about a serious injury, Tony, a severe behavioural disturbance arising out of the work incident itself, Tony.
And it applies obviously in transport accidents?
That's correct. So if you have people who are injured in an accident, the loved ones, family members, friends can lodge a claim if they've sustained, beyond just the normal sorrow and all that, if they've sustained psychiatric
And they do have to
conditions.
lodge a primary claim, don't they?
They have to lodge a claim within 12 months, or there is a further 2 years, which is TAC's discretion to accept.
And in transport accident comp, you need a serious injury.
Well, you need a serious injury for common law damages.
That's right.
Tony.
Yes, to accept.
And under the Wrongs Act, you need more than 10%. Now, can I just read out a bit about the Wrongs Act? This is what they've done. They've codified the whole idea of what happened in Annette's, the law, and it says the things they look at is whether or not the mental harm was suffered as a result of a sudden shock. They look at whether the plaintiff witnessed at the scene a person being killed, injured or put in danger. They also look at the nature of the relationship between the parties. So you need to have some sort of close relationship, loving relationship with the person.
Yeah.
You can't be any stranger that you don't know. And whether or not there's a pre-existing relationship between the plaintiff and the defendant. So someone's got to be at fault as well. You just can't sue for the sake of it, correct?
Yeah, that's right.
Now, give us an example, Don, of where you've seen these principles applied in car accidents.
Well, the most, I guess, which was all over the news, was the Kerrang accident.
Yes?
In the Kerrang accident, which all the viewers will probably know, a truck driver ran into a train that was full of passengers. And a lot of those people who were injured in that transport accident were actually not physically injured.
But
They
they've
sustained
made
mental.
claims for
They
psychological
made
injury.
claims for psychological injury.
Time's flying, viewers. We're going to have to wrap it up and come back to this another time. Don, thanks for coming on board.
Thank you, Don.
And viewers, thanks for watching. Don't go away. Stay tuned because Kathy's coming back with her mailbag. Thank you.